Good evening, everyone. Good evening, everyone. I welcome you all on behalf of the Nalanda. We will start the session shortly. We are waiting for our speakers to join in. So, I welcome you all again on the behalf of the Nalanda. I extend a very warm welcome to all our distinguished speakers, members of legal fraternity, academicians, and everyone who has joined today. It is truly a privilege to have you all with us for the first constitutional lecture of the Nalanda. Before we begin today's discussion, I would like to briefly introduce about the Nalanda. The Nalanda is not merely an organization, but it is an idea. It is inspired by the intellectual and philosophical traditions of the ancient Nalanda, one of the world's greatest center of learning. The name Nalanda itself carries a profound meaning, the giver of knowledge. We seek to embody that spirit by creating a space where knowledge is shared freely, ideas are debated respectfully, and public life is enriched through thoughtful dialogues. Our endeavor is to bring together lawyers, scholars, students, writers, and everybody in the field to engage with question of law, justice, polity, and civilization, and to promote what we call the doctrine of renewal. Now, before moving forward with the session, I would like to briefly conclude that why today's discussion is the need of an art. The topic we are going to discuss today is not merely a legal question, it is a question about the health of our constitutional democracy. Today, we are witnessing increasing public debates around judiciary. Criticism of judicial decision is both natural and constitutionally protected. However, an equally important question arises: where does legitimate criticism end? Where does an organized attempt to weaken constitutional institution begin? So today's lecture becomes important because it helps us understand three foremost questions. That is, first, does freedom of speech include organized political campaigns directed at constitutional institutions? Second, when does criticism strengthen democracy and when can it begin to undermine the rule of law? Third is, what lessons can we draw from the protest following the Supreme Court's 2018 judgment under SC and ST Act and the recent Cockroach Janta Party controversy? With this, I would also highlight our constitutional institutions are strongest when citizens trust them, even while disagreeing with their decisions. In recent year, however, public discourse surrounding the judiciary has become deeply personal and hostile. We have seen instances where former Chief Justice D.Y. Chandrachud publicly acknowledged during his farewell speech and addressed that he had become one of the most trolled Chief Justices. Reports have also emerged of the Chief Justice B.R. Gavai being subjected to an act of disrespect in an open court when footwear was allegedly thrown towards the bench. More recently, during proceedings before a bench headed by Justice Vishwanathan, a party person allegedly used abusive language for current Chief Justice of India, that is Justice Suryakant. These incidents should concern all of us, not because judges are beyond criticism, but because constitutional institutions depend upon public confidence, respect for the rule of law, and civil democratic engagement. With this, I would like to introduce our first speaker, Dr. Arvind Kumar. He is a visiting lecturer in politics and international relations at University of Hertford, United Kingdom. He holds a PhD in politics from Royal Holloway, University of London, and has also served as research associate at SOAS, University of London. His work spans constitutionalism, political theory, democratic institutions, and comparative politics, making him exceptionally well placed to initiate today's discussion. I would like to request Dr. Arvind Kumar. Please, sir.
Hello, hi Anushka and everyone. Uh, Good afternoon, and it is nice to meet you for like this discussion. Uh, it is one of very important topic which needs to be discussed, and I think Raja Chaudhary and his team of Nalanda had stepped in at the right time to discuss this issue. We can if we can see just yesterday's incident, what happened in Indian Supreme Court, where like a litigant not only thrown the paper but also abused Chief Justice of India, like which I haven't heard in last at least 25 years. I have been following Supreme Court since 2000, since 2000 more or less, but more closely I started following Supreme Court since 2005. And I look it as a institution, institution institution of democracy. The people might see like legal scholars see Supreme Court and higher judiciary as an institution, as a neutral observer, but scholars of politics always see it as an ideological institution, and many, just like any other institution which do politics. In our country we do not study judicial politics, but in western country there is proper discipline and research area where judicial politics is studied, like politics which is done through judiciary. But in India that has not been the case. So I am one of the person like who look why like who looks into judicial politics, how judiciary is doing politics. And I see the way, like in subtle way, the way judiciary has involved in playing the political game. It is bound to whatever we are seeing, the crisis in terms of legitimacy crisis. We see like Indian judiciary are gradually like facing legitimacy crisis. So when Chief Justice Levi Chandrachud is saying that he is one of the most trolled judgment. Now you can imagine a judge who is one of the like most astute judge, and trained from Harvard University. He is not able to satisfy the need of the people. There is something serious wrong which is going on, and that wrong, I do not think that. Just yesterday I read some like senior one of the senior advocate has made a comment on Twitter about the judiciary, where he said that there is a concept called echo chamber, where we hear back a similar kind of voices. And he said that actually what is reacting on yesterday's incident, he said that look, what is happening is that judges and advocates have made a part of the closed circle. Maybe it would be circle of 1,000 people or 2,000 people, and where they say good thing about each other, and therefore it is a kind of echo chamber, and they have developed an understanding that that outside of the court premises or outside of our circle we are also getting respected. So so there are few reasons which I think that there few reasons why I think that judiciary is facing such problem. So first problem, if we see like why judiciary exists in any part of the world, and particularly Indian judiciary, a basic question needs to be asked. And fundamental question is that why judiciary exists, particularly higher judiciary. The basic question, it exists for the protection of citizens from state. When I say state, state means government. So anywhere the world, a judiciary exists for that. But over the period, we have been witnessing that Indian judiciary is like has failed to protect the citizen or stand with citizen. And this we can see in terms of like in particularly in India. If we Amit Jadhav is here, like he does research on pendency, increasing pendency. And if we see cases in India, government is the biggest litigant, and like most of the cases which has been filed against the citizen, it is by the government. And when this shows that like if highest litigant in any country is government itself, which has filed the cases against its citizen, it means that there is a serious state repression going on. And in such situation, role of the judiciary becomes very crucial. Now, this situation is not changing. So if we see judiciary, that's why it was always envisioned that there should be clear separation of the power between executive and judiciary. And if we see the literature on Indian judiciary over particularly Supreme Court over last like 10 years, there has been 10, 20 years, there have been 15 years at least, there have been lot of argument which has been made, and now terminology has been deputed as a Supreme Court is called as Supreme Executive Court, which means that rather than Supreme Court being an institution autonomous from the government or separate from the government, when you call Supreme Court as an executive court, scholars have termed it as a executive court. It means that rather than becoming an autonomous institution, independent institution, Supreme Court has turned into a next arm of the executive, or we can say extended arm of the executive. And if government goes to become extended arm of the executive, then problem is gonna to happen. Let us take example of when court starts behaving in that way. So take example of SC/ST Atrocity Act case. When court asked a question to 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 additional solicitor general of India, that oh, there are like a lot of cases, and what we should do. So attorney general, of course, solicitor general, additional solicitor general replied that yes, there are quite lot of cases. And instead of like taking an independent opinion, like a court could have gone in this way, saying that okay, we will appoint a commission and will submit a proper thorough report on this issue, and will look what to be done. But instead of doing that, it immediately went on deciding the matter, and posing strict terms and condition on a particular act about whom you do not know how like it works at the grassroots level. Sometimes, like take for example, if you are thinking like if SCST atrocity act is taken as an example, sometimes people do not want like expectation of litigants or those who are using is not that this person against whom I am filing the case should be punished by the court of the law, by a court. But often, like expectation is that okay, if even one day police arrest this person, that would be sufficient because at the local level, how that is how power operates. Uh, in one of my field work, I met a person who was a teacher, and a a local like landlord, son of local landlords, had beaten him, and that person like just tried to ensure that this person should get arrested way back in 1970s and should be produced before the magistrate. For that he went to the court, he spent quite a lot of money and time, and he ensured that that person got arrested for one day, was produced before the magistrate, and though like next day that fellow got like son of landlord he got a bail. And I asked the person like, why did you spend uh, so much time and energy for doing that? He said that look, it was first time when people come to know in this area that even local landlord can, son of local landlord can get arrested, even though it might be for 1 hour, it might be for 2 hours. So my job was just to ensure. That is how in society like power structure changes. And when judges are making, when they are not able to understand like this grassroots uh, expectation of the people or aspiration of the people or objective what people are expecting, this kind of incidents happen. And this also shows that the protest against Supreme Court's judgment against like SCST Act, the way it has happened across the India, it shows that in one way you can see that it questions the legitimacy of the court, where a section of population says that we do not accept your decision, and that's for a court it is biggest danger. And 2 years ago, Chief Justice D.Y. Chandrachud was here in delivering a lecture in Cambridge University, and I was there in among the audience, and he said that he took example of two three pro poor judgments which Indian Supreme Court has delivered, and tried to build up a case that look, Indian Supreme Court is always pro poor and have taken proactive step. And when I asked this question, gave him counter example and asked that okay, tell me a court in last 10 years across the world where like people have resisted against the court's judgment in that way, and that is poor section of the people, poor section of the society. And he was answerless. He just said that you also need to look that we rectified our judgment later on, but rectification came only after like when people were on street. People being on street against like against the government is one thing, but against the court is another thing. Like if people are against the court, it destroys legitimacy of the court in the society, and it shows very dangerous precedents also, because today one community is doing that, tomorrow like another community will be doing. So these are vicious circle, what we call like similar incidents which can happen in later period. So that's one idea. So I see like one way I see Supreme Court gradually turning into extended arm of the executive. And if it is turning extended arm of the executive, then like protest and other like protest, different kinds of protest are bound to happen. And executive, like power of executives are resisted in multiple ways. You can think of like political parties one way, most sober way, of course, against resistance. And social movement, campaign. But this might, if situation gets worsen, it might results into another kind of protest where people start take like radical steps, when all doors of resistance and addressal grievance addressal gets blocked. So that's one idea. And second idea, which I will use like in this case, is about like Robert Dahl's idea about a political theorist of democracy, Robert Dahl, who made the argument that division of the like separation of power is not enough, but also like diffusion of power in different institutions, and what Dahl calls polyarchy. Amit might correct me later on. And polyarchy means that not only judiciary should function independently, but also other institutions should function should function independently. And role of the judiciary to ensure the functioning of other institutions independently. However, Indian Supreme Court here has also failed very badly. And that you can see, one example I will give you is example of what is happening in the governance of Indian universities. And that one can see, the court have repeatedly passed a judgment saying that actually it vice chancellor, so whosoever is chancellor while acting as a chancellor is not bound to act on the and advice of the council of the states. Now, what it has resulted, so one way, once you made this order saying that chancellor acting as a governor while acting as a chancellor is not bound to act as per the and advice of the council of the ministers. This is what Supreme Court has interpreted. This one judgment said this. Another judgment said that University Grant Commission can pass regulation, and its regulation will 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 supersede the state legislations also. Now, taking these two advices, the University Grant Commission recently passed came up with the regulation and just made a line that Chancellor of all states universities shall be governor. Now, so one way court enabled UGC to pass any kind of regulation which resulted into like completely cutting down, uh, or even I will say legislations of state assemblies have become redundant. So for universities, state level universities, only thing is that University Grant Commission, whatever it will say its its decision is final. It's a regulation, rules and regulation. Now, if you might be looking current controversy, one can see the whosoever would be ruling the central government will have all governors, and same political party will have all its will have like all UGC members and UGC chairman. Now, so universities across the India have turned into rule can be ruled by only two authorities: governor and and UGC office. If you see recently, maybe just after this discussion, some of you might go back and look the what is happening in Bihar. where literally the secretary of governor has issued direction for appointment of five vice chancellor and secretary governor's secretary. And in a constitutional democracy, parliamentary democracy, from where all these orders should get initiate, it should get initiate from the state's higher education department, who is handled by an elected minister, and this court, and no one else, two judges, dy Chandrachud and justice Sundares, Sundares, they have passed this judgment, which has resulted into crisis in of university governance in states such as West Bengal, Kerala, Tamil Nadu over the appointment of vice chancellor, and this thing has come because of the states. Here I see, if you will read Indian constitution, as I said, one of the very source of the power which courts, higher courts particularly acquire, they acquire for the protection of the citizens rights of the citizen, which is through writ petitions. And second way, the second source of the power of theirs is that comes from what is called original jurisdiction, which is protecting the rights of states, conflict between two states or two or more than a state, and states versus center. And here, when we see the conflict between states versus center, the court has enabled, actually over the last like 5, 10, 20 years, court is enabling that, curtailing the power, reducing the power of state legislature or state government, and handing it over to the institutions which are controlled by the union government and the central government. One may ask that what will happen if like state, what is wrong if governors are appointing the vice chancellor of universities. Now you can think of it, you may pose a counter question that if a state government has no control over the universities, nothing, neither appointment nor any kind of thing, why state government will give fund to the universities? And that's like next level of crisis which is unfolding. So, and this has happened because of the courts like short sightedness, I will say, in looking into the consequence of your judgment. So when one is reading the, that's why like policy makers are important rather than the lawyers, because policy makers can speculate in thousand way, their mind work in this way that, oh, if I am going to like make this policy, what could be its other consequences. And Indian courts has not been able to do. And if you are not able to do these things, and there is crisis in India's higher education, who are involved in, who are the stakeholder in higher education? It is the young people, uh, people who are from 16 to 18 year, 16 to 30 year. They are going to be impacted all against like all these mismanagement which is happening in Indian universities. And ultimately it will come back to you on one another day. And with related with this, if you ask to me that, okay, what could have been the better way? Overall, like worldwide, it is the case that vice chancellors and other senior officers of universities, they are appointed by senate or executive council of university. That's a very simple rule. It cannot be appointed by a person sitting in UGC. 3 4 people, a gang of 3 4 people would be appointing whole like vice chancellor and other senior administrative officers of across the country. That is wrong. It is something, it is called iron law of oligarchy, and oligarchy it is creating. So court itself is creating and oligarchy in higher education institution. And related with that is that yeah, so as I said, that court exists for also ensuring that the institutions which are other institutions which are in the country, they should remain autonomous, and they function autonomously. Court's job is to protect those institutions from onslaught of executive, and that Indian Supreme Court has miserably failed in last 20 and 25 years. So that's a second important point. As I said, frustration and another thing. And second last point is the appointment of judges. There is a lot of debate in constitutional law over the sources of sovereignty. And so in sources of sovereignty, several scholars have made point that it is not the it is not only president or parliament holds sovereignty or some share in sovereignty, but also judiciary also holds sovereignty. And I find in other part of the world that that argument is quite valid. Reason is that because judges, there is one way, like previously they have a jury system. So court enjoys not its power only through some written document, but also through the people. So if, for example, in Britain, every person who is living here is like entitled or legally might become part of the jury one day for deciding matters. So every person here, like in when your judicial system, so basically people are extended part of the judicial system itself. If you are able to, if I am able to make clarify that position, so people are part of the judiciary, because any day their name can come up for judiciary. And if judiciary is designed in such a way, then of course it will enjoy higher power from the society, and people will protect it from any onslaught of executive. But as you know that in 1957 that idea was abolished, and then from 1992 onward, second is that every member of the society in a republic form of the government and democratic form of the government, every member of the society should feel that one day I can reach at the highest constitutional position. And that process has, for that we know that article 14 16 invest has provision for equality of opportunity. And if that equality of opportunity is applied, it should be applied in true sense, which means that if you are filling any position, then there should be open call for that position, whether it is judge position of the judge or position of attorney general or any position. Like there should be open call for the position so that people can apply, can make the case that why I think I am suitable for that position. But that route has been blocked. So now you can see judge can be a committee will sit and will decide that among themselves who would be judge. This is a this kind of operation of appointment is much more like, you can say, a function of oligarchy, elite decision, rather than they can take decision, but there should be first process is open call for the position. So anyone who thinks that I am suitable, they can place the application. Then you can eliminate, shortlist, whatever you want to do. But first process has to be uh, to be calling open application, and those provision, like eliminating those provisions, has serious complication in terms of growing distrust against 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 the Supreme Court of India. And lastly, like, if you will read earlier work which was in 1990 till 1989, G.H. Gadbois has written the book called Judges of the Supreme Court. And if you read that book, he has used a theoretical formulation which is called government judges and courts judges, government judges and courts judges. So he used the theoretical formulation of, if a judge was appointed, who initiated the proposal. So whether it was initiation was from the government or initiation was from the chief justice. And based on that, this formulation is used like similar formulation is used in US Supreme Court, where judges are clearly defined in terms of whether they were appointed by Democrat Party or Republican Party. In similar way, similar formulation Gadbois used in India, whether they are appointed from the government side or from like from judiciary. After the collegium system, we know that now proposals are mostly initiated from the from court itself. But over the, like, there are news reports which suggest that now, during itself, like Chanchur's tenure, it came that he gave his colleagues gave statement that while discussing on the name of the judge, he said that we should, like, government will not agree on this name. So a priori it seems that there is a informal discussion with the government, a priori informal discussion, and taking the opinion, taking the feedback on whose name you will agree, then we will place our name. So now, in this way, you can say the, what is called a specter of government judges now has started hunting the Indian judiciary. And if we see that specter is haunting now, because strength of Supreme Court has gone to 34 and 36 judges, I think now it has gone 38 judges, 34 till now, or more than 30, you can see. Now, government doesn't need 30 to 40 judges, just it need 10 judges, 10 to 12 judges. In that 10 to 12 judges, it can, like, uh, while, like, discussion in conversation with CGI, they can formulate favorable constitutional bench, and any judgment can get passed. So that's another big problem. Lastly, once I see there is, like, of late, Indian Supreme Court has unnecessarily started taking, like, unnecessarily it has started entering in every aspect of the of making judgment. So take for example, which has created it for big problem. Though judges do not look the society, they might be much more concerned with sitting in the judgments. And those are, I would say, those cases are related to the, which affect the masses directly. A large number of people gets affected with the cases. So one such case is in Uttar Pradesh. Two cases came in my mind. One case was appointment of, there was a Siksha Mitra. I think Raja would be knowing much better. Some of you know, might be knowing much better. There used to be a Siksha Mitra who were appointed in schools. They were just 12th passed people, and they were appointed in a school in 2000, I think, somewhere in 2000. They were appointed in primary schools for teaching, and later government tried to regularize them. And Supreme Court came heavily on those people. So like a large number of people were appointed, and approximately, like, I think more than 40,000 would have been, at least 4 or 40 or 60,000 people would have been appointed. And I know several people, several Shikshamit, because at least in every village they were appointed, in every school I should say, they were appointed, and government tried to like upgrade them by by assisting them to get like graduation degree and all these things. And because several of them were made like promoted as a teacher, and once you get promoted as a teacher, you know how Indian society works. People took loan, bank loan, they took, they build up houses and all these things for purchasing car and all these things, because their salary got immediately increased. Now court came on heavily on them and said that no, they should be demoted to the to their original position, position. And not only they should get demoted, but also if they have worked for, they have got salary of 5 year for the teachers, their salary should be taken back actually. Now imagine, at theoretical level this might looks good, but at the practical level, if a person is there who has like done all these things, what, how this might result into a crisis. and and most sad part of this is, because of the Supreme Court's judgment, at least more than 200 Shiksha Mitras have committed suicide. So here you can say courts has to exist for the protection of the life of the people, and court have gone into delivering the judgments where people have been forced to commit the suicide. Several of them have gone through depression and other kind of anxieties. And this is so, the one implication of judgment is like people have been forced to commit suicide and other, take other extreme steps. Another implication of the judgment was that when it went for the appeal, then there was like a campaign among the scheduled caste that we can pay 5 crore rupees. If we can pay 5 crore rupees to Supreme Court judge, we will get favorable case in our favor. And informally there was lot of collection. Now imagine if at the village level collection would be made on this name, that we are going to give 5 crore rupees to a judge of the Supreme Court. What is what respect of Indian Supreme Court is going to have in at the village level? And so when Chanchud and others are saying that we are getting trolled, they must know that what is happening at the local level, because of the judgments which in which they are delivering. And similarly, recently another bench of Justice Deepankar Datta went on delivering similar judgment, where there are like teachers who are appointed since 2005. They made the judgment, they gave the judgment, they have to clear the teaching eligibility test. And it has created a panic across these primary teachers, that on the one hand they have gone for preparation, on the other hand, like after certain point of time, even miscreant element in the society can think that, oh, we are going to purchase the judges, give bribe to them in order to get favorable judgment. And believe me, this is one of the reason, like first time I have started witnessing in last 10-15 years, that judgments of the court has started impacting, negatively impacting people at the mass scale, where court should have stood in thinking the protecting the life and life and well-being of the of the weaker section of the people. So instead of going on that line, court have gone into reading the laws in abstract manner. And I think if these situations are continue are going to continue, there is like higher possibility that court will not only consistently lose its like legitimacy, but might face further extreme form of the protest in upcoming days. Thank you.
Thank you, sir. Thank you so much. Your comparative constitutional perspective has given us a broader understanding of how democracy across the world balance freedom of speech and expression with the need to preserve the dignity and independence of judicial institution. Thank you very much. It was so insightful and thought-provoking address. It now gives me a great pleasure to invite next speaker, that is Mr. Sashank sir. Shashank sir is an advocate on record at Supreme Court of India with over 13 years of distinguished legal practice. He is an alumnus of Dr. Ram Manohar Lohia National Law University, Lucknow, and has built an impressive practice over the Supreme Court, particularly in constitutional law and minority right matters. Given today's theme, his practical experience before the Supreme Court offers a valuable legal perspective on the constitutional questions surrounding judicial independence, democratic dissent, and the limits of political mobilization. I request Sir to kindly take over the floor.
थैंक यू अनुष्का, थैंक यू फॉर द अपॉर्चुनिटी। मैं अपनी बात जो है वो हिंदी भाषा में रखना चाहूँगा। मैं थोड़ा सहज फील करता हूँ हिंदी में बोलने में, खासकर इस तरह के प्लेटफॉर्म्स पे। आई थिंक सभी लोग, कोई दक्षिण भाषी तो नहीं होगा, अगर कोई दक्षिण भाषी होगा तो मैं फिर अंग्रेज़ी का यूज़ करूँगा, नहीं तो मैं हिंदी में ही बोलूँगा। तो मेरा ये कहना है कि अरविंद सर ने बहुत सारी बातों को थ्योरेटिकल तरीके से बताया है और बहुत सारी उदाहरण दिए हैं। मेरा नंबर मेरे ख्याल से तीसरा होना चाहिए, क्योंकि जब 2 शिक्षाविद हैं तो ज़्यादा पढ़े 2 शिक्षाविद होते हैं, तो शायद अमित सर को मुझसे पहले बोलना चाहिए तो ज़्यादा बेहतर होता। क्योंकि वो जो एक नज़रिया है जिससे हम लोग उतने रूबरू नहीं होते हैं, उसकी जो माइक्रोस्कोपिक स्टडी होती है, वो बड़ी अच्छे तरीके से करते हैं। मेरा जो ये पूरा प्रकरण हुआ है अभी तक, जिसमें कॉकरोच जनता पार्टी एक सैटारिकल पॉलिटिकल मूवमेंट हुआ, और जिसका कभी इतिहास में अगर पूछा जाएगा कि इसके जनक कौन थे, तो चीफ जस्टिस ऑफ इंडिया का नाम लिया जाएगा कि किस तरीके से ये पार्टी का उदय हुआ। और हालांकि ये पॉलिटिकल पार्टी नहीं है, अभी भी एक मूवमेंट है, और ना ही ये क्लेम किया गया है कि ये पॉलिटिकल पार्टी होगी, और इस बात से परहेज भी नहीं किया गया है कि ये पॉलिटिकल पार्टी नहीं बनेगी। दोनों ही बात है। पूरी बात जो अरविंद सर ने कही उससे मैं इत्तेफाक रखता हूँ। एक बहुत ही दुख है लोगों का, और बहुत ही हतोत्साहित है जो रवैया है 2014 से 2026 के बीच में सर्वोच्च न्यायालय को लेकर। क्योंकि जिस तरह के जजमेंट्स आए हैं, जितने तरह के निर्णय आए हैं, उन्होंने बहुत, खासकर जो भी मानव अधिकार से संबंधित हो और आम नागरिक से संबंधित हो, बहुत सारे कॉर्पोरेट मैटर और बहुत बड़े-बड़े मैटर्स को छोड़ दीजिए, तो वो मामले जिनमें आम जन लोग इन्वॉल्व हैं, चाहे वो मज़दूर के पेंशन का मामला हो, चाहे ग्रेच्युटी का मामला हो, या जैसे इन्होंने ज़िक्र किया शिक्षकों की भर्ती का मामला हो। अभी वर्तमान में उत्तर प्रदेश में 2012, 2016, 2018 की भर्ती के प्रकरण चल रहे हैं, लेकिन अभी तक किसी का भी निस्तारण नहीं हुआ है। ये एक बहुत बड़ी विडंबना है कि लोग बहुत हतोत्साहित हैं। जो भी ये प्रतिक्रिया हुई और इस प्रतिक्रिया में एक पॉलिटिकल मूवमेंट खड़ा हुआ, उसका सुप्रीम कोर्ट ज़िम्मेदार है, क्योंकि अब डिजिटल वर्ल्ड के आने से, सूचना प्रौद्योगिकी के आने से एक क्लोज़ सर्किल में नहीं है, बंद कमरे में सुप्रीम कोर्ट नहीं है, लोगों की नज़रिए में है, और लोगों के नज़रों में भी है कि किस तरीके से ये लोग फंक्शन करते हैं। दूसरी बात ये कि अ, अब जो जो भी सुप्रीम कोर्ट कर रहा है, इस मूवमेंट के बाद उसे भी बड़ा देखना होगा कि किस तरीके से वो इसे लेते हैं। और जो 2-3 इंसिडेंट हुए हैं वो अभी बहुत कम है, क्योंकि मुझे एकदम ऐसा लगता है कि आने वाले वक़्त में और भी ऐसे तरह की जो घटनाएँ हैं वो घटित होंगी। जो नियुक्ति का सवाल है बहुत सारे जजेस का सुप्रीम कोर्ट में, वो एक बहुत बड़ा सवाल है। सवाल ये नहीं कि नियुक्ति किस तरीके से होनी चाहिए। सवाल ये है जो बहुत सारे लोग जो इवन कि जो बहुत लिबरल्स हैं और जो ये बात कहते भी हैं, वो इस बात को कभी नहीं कहते हैं कि इस पूरे नियुक्ति के प्रकरण में या इस पूरे नियुक्ति के सिलसिले में किन लोगों को आना चाहिए, किन लोगों का प्रतिनिधित्व होना चाहिए। क्या ओबीसी समाज के लोगों का प्रतिनिधित्व होना चाहिए? मैंने कभी कभी कोई ऐसा जज का नाम नहीं सुना जिसका सरनेम हम लोगों के जीवन में जो लोग रोज मिलते हैं उन उन लोगों के लोगों जैसा। मैंने कभी किसी का नाम चौरसिया नहीं सुना, किसी जज का नाम। मैंने कभी किसी जज का नाम कुशवाहा नहीं सुना। मैंने कभी किसी जज का नाम सोनकर नहीं सुना। तो ये सब जो बातें हैं, ये बड़े मुद्दे अहम हैं और अभी ये सब चीज़ें किसी न किसी तरह से सामने आएँगी। इस पूरे सुप्रीम कोर्ट में जो ज़्यादातर लिटिगेंट पिछड़ा और बहुजन समाज का है और उसके अंदर की जो वेदना है, जो जस्टिस ना मिलने का दिक्कत है, वो भी है और प्लस जिस तरीके से उसके मामलों का निस्तारण हो रहा है। बहुत सारे लोग एक एलीट और एक बहुत धनाढ्य वर्ग से सुप्रीम कोर्ट में नियुक्तियाँ होती हैं। सबका अगर आप बैकग्राउंड चेक करिए, तो आपकी सबके पृष्ठभूमि में आपको धन का तो एक बहुत बड़ा रोल मिलेगा ही। इक्का-दुक्का लोग, इवन कि जो लोग एक पर्टिकुलर समुदाय से भी आ रहे हैं, उनका भी 2-3 बैकग्राउंड बहुत अलग है। किस लेवल तक वो वहाँ पे जा पाते हैं और क्या बात लोगों के लिए सोच पाते हैं, ये बड़ा महत्वपूर्ण है। तो किसी की जो नींव है वो इतनी पक्की नहीं है जो वहाँ जाके कुछ बदलाव भी कर सके। 1-2 आपको हर हर पूरे 10 साल में 2 या 3 जजेस ऐसे मिल जाते हैं जिनको आप बोल सकते हैं कि वो अच्छा कर रहे हैं। लेकिन ऐसा कुछ अभी बहुत फ़ॉर्मिडेबल नहीं आया है हम लोगों के सामने। क्योंकि उसमें सीधे से हम लोगों का रिप्रेजेंटेशन नहीं है। पॉलिटिकल रिप्रेजेंटेशन तो हो जाता है, लेकिन जजेस का एक जो रिप्रेजेंटेशन है जिसमें आप बात करने लगते हैं कि एक वर्ग के लोगों को आप लाइए, तो ये सांकेतिक रूप से लोगों को लाते हैं। लेकिन ये उस तरीके से नहीं लाते हैं क्योंकि कोई भी मेरिट, जैसे मेरिट इज़ मिसनोमर वाली बात है, वो एकदम यहाँ पे लागू होती है। कि ये लोग एक आभा मंडल इन्होंने क्रिएट किया हुआ है कि इस तरह का व्यक्ति होगा तो इस तरह का व्यक्ति होगा। लेकिन अभी जो समस्या होने वाली है वो ये कि जो हाई कोर्ट के अपॉइंटमेंट्स हो रहे हैं पूरे भारत में, उनकी अगर आप गुणवत्ता देख लीजिए तो आप अपना सर पकड़ लेंगे और यही हाई कोर्ट के निर्णय सुप्रीम कोर्ट में, सर्वोच्च न्यायालय में चैलेंज होंगे। चाहे वो इलाहाबाद हाई कोर्ट हो, चाहे वो आपका पटना हाई कोर्ट हो, या आपका मध्य प्रदेश हाई कोर्ट हो। इस तरीके के लोग जो एक पर्टिकुलर वर्ग से और एक पर्टिकुलर धर्म से और एक पर्टिकुलर सोच से इत्तेफाक रखते हैं, वो इस नियुक्ति प्रक्रिया में के तहत जो है वो उनका चयन हो रहा है। और जब उनके द्वारा पास गए जजमेंट जब आएँगे तो लोगों को बहुत दिक्कत होगी। अभी हाल ही में एक जजमेंट सुप्रीम कोर्ट ने पास किया, कर्नाटक हाई कोर्ट ने पास किया शेड्यूल्ड कास्ट मामले में, जिसमें पब्लिक व्यू में एससी-एसटी एक्ट के इम्प्लीकेशन की बात थी और मैट्रिमोनियल रिलेशन में दाम्पत्य जीवन में अगर कोई एक व्यक्ति अनुलोम-विलोम विवाह करता है और उसमें जो स्पाउस है, जो लड़की है वो शेड्यूल्ड कास्ट फैमिली की है, लेकिन कुछ समय बाद अगर उसे उस लिए गाली दी जाती है दाम्पत्य जीवन में, तो उसे पब्लिक व्यू में ना मान के बोला कि एससी-एसटी एक्ट इन्वोक नहीं हो सकता, ये हाई कोर्ट की रीज़निंग है। अगर आप टेक्निकली पढ़िए एक्ट को, एससी-एसटी एक्ट को, तो आपको समझ में आएगा कि ये बात ठीक कह रहा है। लेकिन यहाँ पे जो जुडिशियल क्रिएशन की ज़रूरत है, जहाँ पे आप ये बात बोल सकते हैं कि क्योंकि इस दोनों सेटिंग में 2 लोगों में कोई तुलना नहीं है, एक का अलग बैकग्राउंड है। लेकिन यहाँ पे कार्व आउट करना सुप्रीम कोर्ट की ज़िम्मेदारी है, लेकिन वो नहीं हुआ। और ऐसे ही चाहे ईडब्ल्यूएस का जजमेंट है, जो ईडब्ल्यूएस की कॉन्स्टिट्यूशनल वैलिडिटी जब चैलेंज की गई, तो अभी उसका असर दिखना शुरू हुआ है। लोग किस तरीके से सर्टिफ़िकेट बनवा रहे हैं और यूपी में एक पूरा माइग्रेशन वाला मामला चल रहा है। तो सुप्रीम कोर्ट ने या हाई कोर्ट इस तरह के ऑर्डर पास नहीं कर रही है, जजमेंट नहीं दे रही है, जो एक पर्टिकुलर वर्ग जो बहुत बड़ा वर्ग है जो रोज़ नौकरी की तलाश में है, जिसके लिए पियोन की नौकरी बड़ी इम्पोर्टेंट है, जिसके लिए जिसके लिए सफाई कर्मचारी की नौकरी बड़ी इम्पोर्टेंट है, उन सब के मामले कई-कई सालों से लदे हुए हैं सुप्रीम कोर्ट में। अभी हाल में इलाहाबाद हाई कोर्ट में एक माइग्रेशन का मामला चल रहा है, जिसमें ओबीसी और एससी-एसटी की मेरिट जो है वो जनरल कैटेगरी की मेरिट से ज़्यादा ऊपर आ रही है। लेकिन जितने भी जो भी राज्य हैं, 5 खासकर जो भाजपा शासित प्रदेश है, उन्होंने एक गवर्नमेंट ऑर्डर पास कर दिया है और उसमें बोला कि हम माइग्रेशन एकदम अंत में लगाएँगे। जब सिलेक्शन हो जाएगा तब हम माइग्रेशन को अप्लाई करेंगे। लेकिन सौरभ यादव का जजमेंट है सुप्रीम कोर्ट का, जस्टिस ललित का, जिसमें उसने बोला है कि माइग्रेशन को आप हर स्टेज पे लगा दें। पर ये सब बातों का मैं ज़िक्र इसलिए कर रहा हूँ कि आप देखिए कि किस तरीके से लोग परेशान हो गए। मतलब पहले तो आप मेरिट की बात करते हैं, जब कोई व्यक्ति अपने आप को साबित करके नंबर लाता है, तो आप जो है ये एक रूल ले आते हैं। तो और ये सब जो सोच है वो आप देखिएगा, अभी आप उठा के देख लीजिए कि जो भर्तियाँ हुई हैं, अगर कोई बहुत अच्छे से एनालिसिस करे और उन सब का एक कास्ट वाइज और वर्ग वाइज अगर आप एनालिसिस करें कितने लोग सेलेक्ट हो रहे हैं खासकर सरकारी नौकरियों में, तो आपको एक साफ-साफ निष्कर्ष मिलेगा कि किस तरह की चीज़ें हो रही हैं और किस मंशा से हो रही है, और अगर राजनीतिक पहल हो रही है तो उस पे ठप्पा सुप्रीम कोर्ट या हाई कोर्ट लगा देती है, खासकर नियुक्तियों के मामले में। और यही पर्यावरण से लेकर के मामला है, जिसमें अभी आपने अरावली हिल वाली बात देखी, जस्टिस गवई का रुख देखा, और बांध की समस्या है, विस्थापन की समस्या है। इन सब मामलों में सुप्रीम कोर्ट बड़ी उदास है। बहुत सारे मामले इंश्योरेंस के मामले पड़े हुए हैं, जिसमें से ये कहा गया है कि इंश्योरेंस कंपनी इंश्योरेंस तो ले लेती है, और जो नई टेक्नोलॉजी आ रही है, प्रीमियम हर साल बढ़ा देती है, लेकिन नई टेक्नोलॉजी को इंक्लूड नहीं करती है अपने उसमें। प्रीमियम को तो हमेशा बढ़ा देती है। इन सब मामलों को लेकर के पब्लिक इंटरेस्ट लिटिगेशन फाइल हुई है। पहले एक सोशल जस्टिस बेंच हुआ करती थी, जो इस तरह के मामलों को देख रही थी, जैसे ललित जस्टिस लोकूर उसको हेड करते थे। लेकिन अब सोशल जस्टिस बेंच नहीं है। बहुत ही सही मुद्दों पे पब्लिक इंटरेस्ट लिटिगेशन की सुनवाई नहीं हो रही है, 10-10 साल लगा रहे हैं। सिर्फ ये मत सोचिए, बहुत सारी राइट टू एजुकेशन के मामले पे अगर कोई शोध करे तो उसको पता चलेगा, जो राइट टू एजुकेशन के मामले हैं जिसमें बच्चों को मना किया गया इस एक एकेडमिक सत्र में, एक शैक्षणिक सत्र में, कि आप एडमिशन मत लीजिए, और उसे उसने हाई कोर्ट में चैलेंज किया, और वो डिसाइड हो रहा है 5 साल बाद, जब वो 5 क्लासेस पार कर गया। तो इस तरह की चीज, लेकिन ये सब जो भी न्याय जो बना है, जो जिससे सबसे ज्यादा फायदा गरीबों को होना चाहिए, उन व्यवस्थाओं पे ये ना तो निर्णय दे पाते हैं और ना ही इतना समय लगा पाते हैं। तो जाहिर सी बात है कि लोगों के अंदर एक एक कुंठा है, एक निराशा है सुप्रीम कोर्ट से कि कभी इन सब मामलों को वो क्यों नहीं आगे बढ़ाते हैं। और जाहिर सी बात है कि जब आप राइट टू एजुकेशन जैसे मामले जिसमें बच्चे इन्वॉल्व हैं, उनको आप प्रायोरिटी नहीं देते हैं। उत्तर प्रदेश में एक स्कूल है सीएमएस, सिटी मॉन्टेसरी स्कूल। पिछले 10-15 सालों से वो आरटी के बच्चों का एडमिशन नहीं ले रहा है। उसकी इतनी सारी ब्रांचेज़ हैं, गिनीज बुक ऑफ वर्ल्ड में उसका रिकॉर्ड है कि इसकी बहुत सारी ब्रांचेज़ है, बहुत अच्छा काम करते हैं ये लोग। लेकिन हर साल सुप्रीम कोर्ट में उनका एक मुकदमा लंबित है जो पिछले 10 सालों से है, और सुप्रीम कोर्ट उसकी सुनवाई नहीं कर रही है, उसमें स्टे लगा रखा है। तो बात ये है कि आप किन मुद्दों को प्राथमिकता देते हैं, ये भी बड़ा महत्व है। आप लोगों को जो असर कर रही हैं उनके दैनिक जीवन में, उनसे रिलेटेड मुद्दों को आपने जो है एकदम दरकिनार कर रखा है। और आप अगर अभी कोई आर्बिट्रेशन का मामला हो, और कोई आप औद्योगिक घरानों के बीच की लड़ाई हो, करिश्मा कपूर का मेडिएशन का मामला हो, तो उन सब मामलों में आप बहुत त्वरित गति से निर्णय देते हैं। लेकिन जो आम जन को प्रभावित करता है वो बहुत सारे लंबित हैं। इनको इस बात पे सोचना चाहिए, बल्कि ये जो इंसिडेंट हुआ है, ये घटना हुई है, ये इनके लिए आत्म अवलोकन का समय समय है। इनको समझना चाहिए, और लगातार ऐसी चीजें हो रही हैं। तो अब तो इन्हें ये बात सोचनी चाहिए कि किस तरीके से इन्होंने एक जगह दी लोगों को, और अब वो वक्त दूर नहीं कि जब लोग सड़कों के बाद जो है वो सुप्रीम कोर्ट के सामने ना बैठने लगे। बहुत पहले एक बार हुआ था जब इन्होंने ये वो नर्मदा बचाओ आंदोलन में एक इन्होंने जो निर्णय दिया था बांध से रिलेटेड, तब बहुत सारे एक्टिविस्टों ने जो है गंगा जल से सफाई की थी सुप्रीम कोर्ट की। उन्हें बहुत सारे मामलों में अंदर कर लिया गया। तो कहने का लबोलबाब ये है कि बहुत सारे जो सुप्रीम कोर्ट ने जो अभी निर्णय दिए हैं और जिन बहुत सारे मामलों को पेंडिंग रखा है, ये इसकी पूरी रिपोर्ट, ये रिएक्शन ऐसा नहीं है कि मुझे लगा कि एकदम तुरंत रिएक्शन हो गया या उन्होंने ऐसा कुछ बोल दिया और लोगों ने बना दिया। लोगों के अंदर गुस्सा बहुत सालों से एकत्रित हुआ है और ये रिएक्शन मुझे ऐसा नहीं लगता कि बहुत त्वरित प्रतिक्रिया में दिया गया है। लोगों का संजोया हुआ दुख है जो इस पॉलिटिकल मूवमेंट में सामने आया है। कितना सही है, कितना गलत है, ये एक अलग मुद्दा है। इट्स टू अर्ली टू कमेंट ऑन दिस पर्टिकुलर डेवलपमेंट वेदर दिस इज राइट और रॉन्ग, बट सुप्रीम कोर्ट हैज कंट्रीब्यूटेड, सुप्रीम कोर्ट हैज कंट्रीब्यूटेड बिकॉज ऑफ दिस थिंग, ये पॉलिटिकल मूवमेंट खड़ा हुआ है। बहुत सारे लोगों की इसमें क्योंकि जब मेरी बात हो रही थी तो बताया गया था कि इससे इतर कि क्या ये जो कॉकरोच जनता पार्टी है ये पॉलिटिकल पार्टी बनेगी कि नहीं, और क्या इन्होंने इनको सिंबल मिलेगा कि नहीं। तो उन सब के एक लीगल पहलू हैं जिसमें ये एक बात कही गई है कि अभी तक तो इन्होंने कोई ऐसा रजिस्ट्रेशन का प्रक्रिया अपनाई नहीं है। और सिंबल की बात है तो वो 1968 का जो इनका रूल है उससे गवर्न होता है। तो वो खैर उसमें जाने की मेरे ख्याल से ज़रूरत नहीं है, क्योंकि जो ये स्टडी मुझे ऐसा लगता है जिसका टॉपिक होना चाहिए कि ये एक सटाइकल पॉलिटिकल मूवमेंट सुप्रीम कोर्ट की प्रतिक्रिया में बना बना है कि नहीं है, इस बात पे होना चाहिए। क्योंकि कोई भी पॉलिटिकल पार्टी मेरे ख्याल किसी संस्था के विरोध में नहीं बन सकती है, जहाँ तक मुझे ऐसा लगता है। तो ये यही सब बातें मैं कहना चाहूँगा। मुझे लगता है कि अमित सर ज़्यादा अच्छे से बताएँगे बाकी चीज़ों को। थैंक यू, अनुष्का।
थैंक यू शशांक सर। आपने आज सिर्फ एक लीगल पर्सपेक्टिव नहीं रखा, बल्कि जुडिशरी के सामने मौजूद कई महत्वपूर्ण कॉन्स्टिट्यूशनल चैलेंजेस पर भी बात करी, जैसे जुडिशियल अपॉइंटमेंट्स, रिप्रेजेंटेशन जुडिशरी, ये सब भी।
अनुष्का, एक बात मैं बस, क्योंकि बहुत महत्वपूर्ण बात है इसलिए मैं बोलना चाह रहा हूँ, जो मैंने सोचा था बोलूँगा। पूरे सुप्रीम कोर्ट में सिर्फ जो नियुक्ति का मामला जजेस से रिलेटेड नहीं है, ये नियुक्ति का मामला उन लोगों से भी रिलेटेड है जो जो सरकार को रिप्रेजेंट करते हैं। इतने सारे राज्यों के लोग जो स्टैंडिंग काउंसिल हैं या एजी हैं, अगर आप पिछले 20-25 सालों के लोगों को देख लीजिए और जो समाजवादी सरकार की गवर्नमेंट है उसको हटा के देख लीजिए, तो ज़्यादातर लोग सवर्ण समाज के हैं। और मुझे समझ में नहीं आता उत्तर प्रदेश जैसे राज्य में जहाँ की आधे से ज़्यादा जनसंख्या, आधी से ज़्यादा क्या, मेरे ख्याल से 75% जनसंख्या जो है वो बहुजन है, वहाँ 32 स्टैंडिंग काउंसिल में एक स्टैंडिंग काउंसिल जो है वो ओबीसी समाज का है, बाकी कोई भी नहीं है, ना तो एससी एसटी। और जब ऐसे लोगों को ये स्टैंडिंग काउंसिल नहीं बनाएंगे तो बाकी लोग जज कैसे बनेंगे, क्योंकि ज़्यादातर लोग, वो पहली सीढ़ी होती है, आपके पास बहुत सारा एक्सपोजर होता है। तो ये एक ऐसी चीज़ है जिस पे भी सोचना चाहिए, और ये भी एक विषय है जिस पे जो लोगों को बहुत क्रोधित करता है, क्योंकि आप हमेशा, ये कहा जाता था हम लोग के मूवमेंट के समय कि जिसकी लड़ाई उसकी अगुवाई होनी चाहिए। और ये नदारत है सुप्रीम कोर्ट में कि लड़ाई आप ओबीसी की लड़ते हैं लेकिन लड़ता वकील जो है वो सवर्ण है। तो इतने सालों में आप ना तो ये कोई इस तरह का माहौल दे पाए हैं, जो भी लोग लड़ के आए हैं वो एक उनका बैकग्राउंड रहा किसी तरीके से, लेकिन एक साधारण व्यक्ति आपको फिल्मों में नवाजुद्दीन सिद्दीकी जैसा कोई आपको एक वकील नहीं मिल जाता है वकालत में, कि कोई नवाजुद्दीन सिद्दीकी सिद्दीकी आ जाए वकालत के लिए। थैंक यू, ओवर टू अमित सर।
Thank you, sir. Your views are very important to us and gave a lot to us to think about. We sincerely thank you for sharing your experience and insights for today. With this, moving forward, I feel very privileged to introduce our third speaker for the evening, Dr. Amit Jadhav. Dr. Jadhav is a PhD scholar in political science at the University of Wisconsin-Madison. He holds a PhD in consumer science and MA in political science, reflecting an interdisciplinary academic journey that bridges the social sciences, economics, and public policy. With this, I would like to invite Sir and hand over the floor, virtual floor to you, sir.
Thanks, Anushika, and good evening, everyone. And first of all, thank you for organizing this event, and Dr. Raja Chaudhary, Advocate Raja Chaudhary, and the Nalanda team for inviting me as a guest speaker. And also, I would like to thanks first to great speaker Dr. Arvind Kumar and Advocate Sashank Kumar for sharing their excellent views on this topic, and which will help me to discuss this topic through the political science lens. So, since my background is in political science, so I will discuss this today's topic through the lens of political scientist, and my discussion will be purely academic. So I would like to start this discussion with a simple thought experiment. Suppose a group of citizens is dissatisfied with the government and they organize a protest, and we have seen in many episodes, and they can establish the association and can even create a political party to oppose that policy. So we would regard that as a ordinary feature of democracy. Now, suppose that their dissatisfaction is not directed towards the government, but against the judgment or the statement of the Supreme Court. So my question is: does that change the democratic character of their mobilization? Can citizens organize politically against a court while continuing respect for the constitution, or does organizing against a Supreme Court necessarily undermine judicial independence? So these are all topics which I study currently in my research. So these questions have acquired contemporary relevance because the emergence of so-called Cockroach Janata Party and this movement have reportedly began after remarks made during the Supreme Court proceedings. And these remarks were subsequently clarified, but the language nevertheless generated a strong public reaction. And then the satirical online identity soon developed into a wider platform through which some young people express concern about different issues like employment, examination, education, and institutional accountability. But I will go into the some details about what is political party. So party in its name should be treated cautiously because it may not resemble a conventional political party with a former membership candidate territorial organization or a complete electoral manifesto, which we see. So it should better understood at least at this stage as a political movement using vocabulary and symbolism of a party. And so recent reporting indicates that it has moved from online satire to a public protest and some organizational development. So my purpose today here is not to support or oppose this movement or evaluate the motives of its participant or comment any political party or public official. Instead, I want to use this episode as a political science case study. So the central question here is: when does the mobilization against a court represent legitimate democratic participation, and when might it become a threat to judicial independence? To answer this, the second episode in this discussion is about Supreme Court 2018 judgment concerning Scheduled Caste and Scheduled Tribe provision of Atrocity Act. So although these two episodes are different, uh, but when I compare both of these episodes, these episodes reveal something important about relationship between courts and democratic parties. So from when we start about comparing an institution, so the political scientists begin with a basic observation, like as Dr. Arvind Kumar also mentioned, like about the courts are obviously a powerful institution, but they are not elected institution. So a government can claim that if the mandate comes from a voter, but the court cannot make the same claim, and judicial authority instead rest on the other means like constitution, legal reasoning, institutional independence, and public acceptance of judicial process. And courts generally do not possess their own machinery from implementing every judgment, so they have to depend on other factors like government administration and other implementation partners. So this means the public confidence, which also include a public confidence, because it is not merely desirable for a court; it is one of the foundation for the judicial power. And Dr. Arvind Kumar mentioned about Robert Dahl. So I would like to also mention about another political scientist, James Gibson. He distinguished between specific support and diffuse support. So the specific support is like specific support to any judgment or statement or to a judge, but diffuse support is like much deeper, and it's about a legitimacy of any institution. So it concerns when the people continue to regard the court as court itself as a legitimate institution, even after if it produces the outcome they dislike. So one can say I strongly disagree with the judgment, but I accept the authority of the court, and that disagreement accompanied by this diffused or deeper institutional support. Um, so, uh, so the democratic difficulty arises when the dissatisfaction with the decision and the statement becomes opposition to the institution as a whole. So our today's discussion is, can a political party built against a Supreme Court therefore contains important ambiguity. Another question is, does against the Supreme Court means opposition to the specific judgment, statement, doctrine, or institutional practice, or does it mean opposition to legitimate existence or authority of the independent judiciary? I think they are not the same thing. So I would like to start with the 2018 SCST Act protest. So what it teaches us, and how the all the institutions like we have like involved in that process. So we know like it started on March 2018 in the case of Subhash Kashinath Mahajan versus State of Maharashtra, and Supreme Court expressed concern about the possible misuse of SCST Prevention of Atrocities Act. And among direction, it introduced a safeguard relating to arrest and preliminary inquiry, and that held anticipatory bail was not absolutely bailed, where no prima facie case existed, and that leads to some communities understood the decision differently, and that leads to the protest on streets. And there was also Bharat Bandh organized on April 2nd, 2018. So this protest generated a political and institutional response. The union government sought review of the judgment. Then Parliament subsequently amended the legislation to restore the protection pursued as diluted. And then Supreme Court later recalled that significant portion of its earlier direction. And in 2020, it upheld the constitutional validity of Parliament amendment, which is subjected to the interpretation of the statute. So I would like to highlight political significance of how how the how these two cases are different. So the political sequence of this political significance is, like, the first court delivered a judgment, then citizens mobilized against the perceived consequences, and then elected government responded, and then parliament legislated, and then finally judiciary subsequently reconsidered the issue. So this is not a simple confrontation between the people and the court. So it was an example of like how the interaction among the court, social groups, and elected institutions and public opinion is matters like in democracy. So one could also view this episode negatively as an instance where the public pressure was directed against the judicial decision making, but one could also view it as a form of democratic dialogue. So citizens communicated that the court's legal reasoning had consequences that can affect their security and a sense of an equal citizenship. And then Parliament then exercises its own constitutional authority to amend that law. So in this case, the political science would ask us not merely whether the protesters were for or against the court. It asks how the judicial decision changed the political incentives, or activated collective identities, and produce responses from other constitutional institutions. So now what so I would like to highlight one feature of both of these Cockroach Janata Party movement and 2018 protests, because they differ substantially in their social and foundation seriousness and organization and immediate demand. So the one feature, so I have like noted like few features. One feature I like to highlight is both episodes demonstrate that the citizens evaluate courts not only reading legal judgment, they also evaluate whether the court recognize their experiences and treat them with dignity. And I would like to also cite other political scientist Tom Tyler's work on procedural justice, and I think it's relevant here because He said like people are more willing to accept decision, even unfavorable decisions, when they believe that the procedure was fair, that they were treated respectively, and that the authority listened to their concern. So I think this was the feature I think which is closely relevant to both of these cases. Um, so then there is also strong democratic argument for and please stop me like if I about to complete my time. So there is a strong democratic argument for permitting political mobilizations around criticism of judiciary, because the courts exercise public power, they interpret laws, they review executive actions, determine rights, and sometimes resolve questions with major social and political consequences. Uh, uh, and so no institution exercising such authority can be completely insulated from public examination. So the judicial independence means that judges should be able to decide cases without threats, inducement, partisan control, or fear of retaliation. But it does not mean that the judicial reasoning, institutional procedure, public statement, appointments, or accessibility, delays, or social consequences must remain beyond criticism. And indeed, the criticism can sometimes help institutions to identify failures that are not visible from within, which has in the this point was highlighted in the first two speakers talk. And what is the risk of organizing against the court? So I'm going very briefly. Uh, so. Uh, So courts are often required to make unpopular decisions. Their constitutional role sometimes require them to protect individual minorities, opposition groups, and other groups. Um, um, but every unfavorable judgment produces a campaign to personally delegitimize judges or punish the institutions. Meaningfully, judicial independence become difficult, and the political mobilization become dangerous when it moves from criticizing judges' reasoning to threatening judges, and from proposing legal reform to rejecting all binding judicial authority, or from demanding accountability to seeking complete political control over courts. So there is also risk of describing every judicial disagreement as evidence of corruption, conspiracy, or partisan loyalty without adequate evidence. Such claims can weaken the public trust without improving the institutional accountability. So this does not mean that citizens should speak politely all time, and that satire has no place in democracy. The political expression is frequently sometimes emotional, sometimes humorous, sometimes exaggerated or confrontational. And the relevant distinction is not between the respectful or disrespectful language alone. The more important distinction is contestation and coercion. Um, can a party actually build against a Supreme Court? Uh, so I want to return this to this central question, and then I will conclude. So can a political party build against the Supreme Court of India? So in an organization sense, like as a scholar, a political science scholar, so I can say a movement can certainly originate from opposition to court, judgment, statement, or institutional practice. And political parties have often emerged from these specific grievances, or from protest movements, or any regional demand, or campaigning for institutional reform. But opposition is rarely enough to sustain the party. So we know like what is the definition of political party, and we argue that like the Cockney Janata Party is still not a party. So why? Because the durable party must eventually answer questions that protest movement can postpone. Like what policy does that political party support? Whom does it seeks to represent? How will it select leaders from and candidates? How will it make internal decisions? Will it accept electoral defeat? And will it respect adverse judicial decision while seeking change the law through constitutional means? And most importantly, I think what is that party for, and rather than merely what is it against. So the political party committed to a lawful judicial reform is different from a political party committed to subordinating a court's political authority. A movement that citizens are one judgment is different from a movement that denies the legitimacy of constitutional adjudication. Then I would like to conclude with this. I think we are I think already late. So I would like to conclude with a few things like to answer this question for today's discussion. Like, yeah, does a political party can build against the Supreme Court or any institutions? So my answer is yes. A political movement, perhaps eventually a political party, can emerge from position to Supreme Court decision, statement, or institutional practice. But a democratic party cannot define by only a hostility towards court. It must demonstrate that it seeks reform through constitutional methods while preserving the judiciary's capacity to act independently. And the real test is not whether the citizens agree with the Supreme Court. The real test is whether disagreement remains part of constitutional democracy rather than becoming an attempt to dismantle its institutional foundation. Thank you.
Thank you, sir. Thank you so much. Your interdisciplinary perspective has added an important dimension to today's discussion. And the way you made us explain the difference between political party and political movement which is going on, I would like to thank you, sir. With this, we now move to the interactive question and answer session. Participants may either raise their hands or write their question in the chat box. Mr. Shailesh Kumar may unmute himself and ask the question.
Hi, can you hear me?
Yes, 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 please.
Okay, thank you. Thanks so much to all the three speakers for this very enlightening talk. I think you all covered a very wide range of topics and issues. So my couple of questions I have, and of course some points I'd like to add to what was said, starting with Dr. Arvind Kumar. I was wondering, because education was initially in the state list. It wasn't in the concurrent list. It was moved to concurrent list in 1976 through the 42nd Amendment, which is very infamous, done by Indira Gandhi. So I was wondering, and also you talked about why the state government should fund an institution if it can't appoint vice chancellors in those universities, right? So I was thinking, should we not look at it from rather than control lens or perspective, than welfare state perspective, that because state is responsible to provide higher education, so they should not look for whether we have the power to appoint vice chancellors or not, be it central government or the state government. And do you think that should we then move education subject back to the state list than concurrent list? So that's one. Second, a very good point on jury trials. And I think India did have jury trials after independence. I think it was abolished in 1960, and I'm sure most of you might be aware of it. The Nanavati case, which was also then converted into a movie starring Akshay Kumar. So the reason is, of course, how the media and the jury trial played a very distinctive role in that case, and how Nanavati, who was initially acquitted by the jury, was later on convicted by the court. And that led to the abolition of jury trials. So again, another question following this, do you think a jury trial in today's time, or let's say a jury, is or should be a welcome step in the judicial structure of India as it stands now, considering all the media, role of media, social media, and the way the Indian society is hierarchized around caste, religion, gender, and so on and so forth? And then I think I also recall a very good book, because I think you mentioned Gadboy's book, which is very, very good text. I think all of us should read. Another one is Court on Trial, a very recently published book, I think a few years ago, by Aparna Chandra and Kalantri and Hobart. And it gives a very I think, excellent account of Supreme Court and how the cases go there. And it argues, I think I can recall 2 or 3 points, and especially for lawyers here or would be lawyers, that'll be very interesting how power works. So I think they argued through data that the Supreme Court hasn't lived up to the idea of or the ideals of justice, equality. Why? Because one, of course, there's a lot of delay, and there are a select group of senior advocates who exercise disproportionate influence on the outcome of cases. And then, of course, there is some politics done by CGI as well in assigning cases, looking at what potential outcome they want. So again, this brings us back to the question of should there be a collegium, or should there be a system, a commission, which I think Arvind talked about as well. Like in the UK, we have Judicial Appointments Commission, and I think in India also it was debated. But then in Judicial Appointments Commission in the UK, you have lay member as well. So they have professional members, they have judicial members, and they have lay members. So is India equipped enough to have this kind of a commission, which is going beyond executive? So it shouldn't be just the ministers and judiciary, but also some academicians or some, like say here, one of the members presently in the JSC in the UK is a former army officer. There are two professors as well of law. So is India ready for it? Can it be done? So these are the questions to Dr. Arvind Kumar. Second, I come to Shashank Singh quickly. Again, thank you so much for your insightful talk. I think I was wondering, even pre-2014, it's not a post-2014 kind of politics. Pre-2014 also, judiciary has been an extended branch of executive. And of course, we all know um, the 42nd Amendment, and of course the ADM Jabalpur case, and how Justice Khanna, kind of lost his CJI-ship because he spoke against the then Indira Gandhi government, right? So it has been there before as well. And I think recently the point you raised about the diversity, representation, and power. I think recently in Patna High Court there were 7 judges appointed from the lawyer route, and I think all 7, if I'm not wrong, you can correct me if you have that knowledge, from upper so-called upper castes. Though still, and for a good time, I think there was not a single women judge as well in Patna High Court. And even after 7 judges appointments, still lacks like 9 judges. So the total capacity is 53 in Patna High Court, it's still 44. So what do you see could be a potential, let's say, way of moving in this positive direction of having a diversified judiciary? And similarly for, let's say, standing counsel, AG, SG and all, do you think an AOR kind exam would be suitable for even appointing standing counsels, AGs, and SGs? Or do you have any other idea that we can explore, both as academic and legal professionals? And how do you see the role of state bar councils as well, if you have any idea? Because in my research, and my fieldwork as well, while doing my PhD and MPhil, I realized that even state bar councils are a big chamber of, caste hierarchy or caste power. So how do you see state bar councils' role in that as well? And finally, I won't take much time. Amit Jadhav, thank you so much again. You talked about Tyler's procedural justice. I would like to add, I think, therapeutic justice or therapeutic jurisprudence to that as well, which is how law can act as a therapy for the defendants in courts or other court uses. And I think David Wexler and Bruce Winnick have done excellent works on therapeutic justice. And I think in the Indian context, a bit of that is reflected in POXO courts or POXO special trials, where, especially in Delhi, where now the child witness is completely removed from the court and appears through digital mechanism. So, what do you see, let's say, in near future, how that can be incorporated in other, let's say, courts or in other ways in which different democratic institutions can work in India? That's all. Thank you so much.
Thank you, Shilesh. Do we have any other questions or inputs which anybody would like to put forth in the forum? In case of queries, you can also write them in the chat box. Well, without taking much time, I would like to conclude the session. by mentioning that this discussion recognize the constitution guarantees the freedom of speech, association, and political participation. At the same time, it also requires respect for judicial independence and the rule of law. When criticism ends and attempts to undermine constitutional institutions begin remain a matter of serious constitutional concerns. The question remains open for deeper thinkers. Where should constitutional democracy draw the line between legitimate democratic dissent and organized political mobilization that may erode the independence, authority, or public confidence in the judiciary? I would like to request the speakers to answer the questions put forth by the Shilesh Kumar earlier.
Yes.
Shank sir, you may proceed. Arvind sir is proceeding. Arvind sir, please.
Just give me a moment. Yeah. Okay. So yeah. So that's questions are very like interesting questions, and thank you for asking those questions. So first is about education. Moving education from from state list to uh, to concurrent list. It has like it now it has serious implications. It's a serious implication are now visible. uh, and if we see, take for example, if I ask this question, if education would have been in the state list, what implications will it have on like what constitutional implications it would have? One may say that like if state government, was it preventing state government to to establish new institutions, or was it was it preventing state central government to 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 like introduce new measures of education? I do not think, because constitutionally Indian constitution allows union government to make law related to the any any subject which is delegated, which is in subject list, provided that for that law in Rajya Sabha there should be two-third majority. That's a very simple thing. I think Indian, like framers of Indian constitution, has given for every for these kind of minuscule issue, they had provided a mechanism for like to have a say to the union government, even if a subject in state list. But problem was that, so court would have, in these cases, when central government is trying to alter the list, altering the list means altering the balance of the power. You are taking control from states to center, greater say of the center in in these issues. If central government is trying to do, we need to also look about the time periods, like what is happening at the front of politics, grassroots level of the politics, what's happening. uh, these were the periods when like states government earlier, like from before 1969, state governments and central government were mostly ruled by the by a single political party, Congress party. But from 1969 onwards, 66 onwards, in 66 election, there were six government which were non-Congress government was formed. So when there was, and not only non-Congress government, but another important feature was that mid governments which were dominated by middle class, what is called agrarian castes, they started coming into the legislatures. I mean, I when I see all these changes, like I cannot imagine these changes. Like I can give the meaning while taking the political development which were happening in the country. So so I think that shifting from, like, when you are seeing that, okay, at the state level there is going to be big change in the government, then what one can do, just the change, the alter the subject matter itself, take something from states and move it to the in the domain of the center. So you will have the government, but actually those people will not be responsible. That is how, like, real everyday real politics function. So, like, another example I will give you. During UPA 1 regime, there was ministers from, like, DMK, RJD, and other political parties. Now, ideally, decisions should be taken, council of ministers decisions should be taken at the table of council of cabinet table, where you will have ministers from all the political parties. But if you will look into the way those decisions were made during the government, they invented a new concept which is called group of the ministers. So decisions, so if any agenda was placed on the cabinet meeting, so prime minister just say, okay, let us send this matter to the group of the minister. And who are the group of the minister who will take the decision? It was Pranab Mukherjee, P. Chidambaram, Kapil Sibbal, and Salman Khurshid. 4 5 people would be making the decision and will say, formally say that, oh, we have taken the decision, just you should approve it. So these are the processes, like everyday practices, how leaders get excluded from effective decision making process. Same happened with education. So, like, gradually attempts were made that to take over the power, but initially the 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 approach of the Supreme Court was to protect the state universities, and it protected state universities in the way saying that UGC is an statutory body, and universities came come into existence through state legislature. So if any instruction, any like any order of the UGC has to be rectified by the Senate or Executive Council of the university, that was theoretical, like, legal justification which was given by the Supreme Court, which has controlled the university, inventing a new mechanism for taking the control. Now court has shifted from that interpretation. Maybe, like, I think after, like, 2010, it has shifted from that interpretation and started saying that actually the rules and regulations which are passed by university or grant commission are actually, they comes into subordinate legislation. And because they are subordinate legislation and education is part of the concurrent list, therefore subordinate legislation will proceed over the state legislation, and that has empowered UGC to pass any kind of act. So when it tried to do, different state governments says that, okay, हम जो है व्हाट वी विल डू कि हम एक एक्ट बनाएंगे जिसमें चीफ मिनिस्टर को गवर्नर बना देंगे, चीफ मिनिस्टर को चांसलर बना देंगे. फ्यू स्टेट गवर्नमेंट ट्राई टू डू. सो यूजीसी ने एक रूल पास कर दिया, उसमें एक रूल लगा दिया कि सारी यूनिवर्सिटी का चांसलर जो है राज्यपाल ही होगा. नाउ, सो विधानसभा उस पर कानून ही नहीं बना सकती, अगर वो बनाएंगी तब भी यूजीसी का रूल प्रिवेल करेगा. अब आप जो शैलेश जी ने क्वेश्चन पूछा है कि एजुकेशन एज ए वेलफेयर मेजर स्टेट गवर्नमेंट क्यों नहीं फंड करेंगी. देखिए, स्टेट गवर्नमेंट एजुकेशन एजुकेशन को फंड जो है मल्टीपल तरीके से कर सकती है. अगर स्टेट गवर्नमेंट, स्टेट की विधानसभा का किसी इंस्टीट्यूशन पर कोई कंट्रोल नहीं है, उसकी अकाउंटेबल मैकेनिज्म अकाउंटेबिलिटी का उस पर कोई मैकेनिज्म नहीं है, कोई कंट्रोल नहीं रह जाता है, तो वो उस जगह पर पैसा क्यों डालेंगी अपनी अपने 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 पैसे को बर्बाद करने के लिए, रेदर देन दे विल गो फॉर लाइक दे माइट गो फॉर गिविंग स्कॉलरशिप, कहेंगे कि हम आपको स्कॉलरशिप दे देंगे, फंड रिफंड कर देंगे, आप प्राइवेट इंस्टीट्यूट में पढ़ लीजिए, जो है जो कि हुआ है बहुत ढेर सारी जगहों पर। लोकल लेवल पे स्टूडेंट्स प्राइवेट कॉलेजेस वगैरह में बहुत मैसिवली जाना शुरू किए हैं, और एक ये रीज़न है जिसकी वजह से शायद जो है स्टेट गवर्नमेंट आने वाले दिनों में अगर उनकी कंट्रोलिंग अपॉइंटिंग अथॉरिटी और कोई भी अथॉरिटी नहीं रहेगी, तो वो क्यों फंड करेंगे। एंड सेकेंडली मोस्ट इम्पॉर्टेंट थिंग इज यूनिवर्सिटीज हमारे यहाँ आप जानते हैं कि एक बहुत बड़ा प्लेस है पॉलिटिक्स का, कि जो एवरीडे पॉलिटिक्स, सो इफ गवर्नर्स आर इन्वॉल्व्ड in politics, in everyday politics of state through the universities, it is going to create disaster. उत्तर प्रदेश की केस में मुझे लोग बताते हैं कि जो कहते हैं कि हाँ, एक और भी चीज कुछ दिनों में आया है, जब से जो है यूपी के एक गवर्नर थे राम नरेश यादव, बिहार मध्य प्रदेश में, when he was governor and his son was found dead in Lucknow. So it resulted into so many speculation कि जो है गवर्नर जो वाइस चांसलर्स हैं इनके अपॉइंटमेंट में बहुत पैसा चलना शुरू हो गया है, और उनके बेटे लखनऊ में ऐसा जो है लोग कहते थे कि जो उनके बेटे की डेथ हुई है वो ऐसे ही बड़े पैसे के लेन देन में हुई है, और बहुत ये जो है इस पर बहुत ज़्यादा कंसर्न्स आना शुरू हो गया है कि गवर्नर की ऑफिस अपने आप में उस तरह कन्वर्ट हो गई जो सुप्रीम कोर्ट के डिसीजन की वजह से, कि अब वो इन्वॉल्व हो गई कलेक्शन और पैसा और इन सारी चीज़ों में। इसमें एक और इम्पॉर्टेंट चीज़ है कि यहाँ से एक प्रॉब्लम और भी देख लीजिए कि क्या प्रॉब्लम जनरेट हुई है। वो आप सभी लोग जानते हैं कि मीन्स हम जानते हैं कि इंडिया में प्रेसिडेंट और गवर्नर्स को अरेस्ट नहीं किया जा सकता है क्रिमिनल ऑफेंसेस के लिए, और एंड दिस हैज रिजल्टेड इनटू बिग प्रॉब्लम कि अगर गवर्नर ऑफिसेज इन्वॉल्व हो गई अपॉइंटमेंट ऑफ वाइस चांसलर्स के करप्शन में, मैं नाम भी बता सकता हूँ इनफॉर्मली कि जिनके जिनके नाम चल रहे हैं कि कैसे जो है फलाना वाइस चांसलर, ये अब एक नॉर्मल बात हो गई है कि ये डिस्कशन की जो है फलाना, मैं उत्तर प्रदेश को बहुत क्लियरली क्लोजली ऑब्जर्व करता हूँ, तो वहाँ एक नॉर्मल बात हो गई है कि फलाना वाइस चांसलर को अपॉइंटमेंट में 20,000 2 लाख 3 करोड़ या 4 करोड़ जो है ये पैसे चल रहे हैं। इसी से रिलेटेड एक और चीज है कि कभी कभी हम लोग जो है मतलब एंगल अपना एक एक खास एंगल से देखने की चीज कोशिश करते हैं। सो गवर्नमेंट ऑफ इंडिया ने, एजुकेशन मिनिस्ट्री ने पिछले 6 महीना पहले एक सर्कुलर जारी करवाया है यूनिवर्सिटीज को कि वो नॉन फाउंड सुटेबल जो है कैंडिडेट्स को ना डिक्लेयर करें। और कुछ दिनों से मैं ये क्लियरली देखने की कोशिश कर रहा था कि अच्छा कौन से कैंडिडेट हैं जो नॉन फाउंड सुटेबल डिक्लेयर हो रहे हैं, तो जाहिर सी बात है कि मेजॉरिटी ऑफ देम आर फ्रॉम या प्रीडोमिनेंटली जो है वो हैं शेड्यूल कास्ट और शेड्यूल ट्राइब ओबीसी कैंडिडेट्स यूनिवर्सिटीज में नॉन सुटेबल डिक्लेयर हो रहे हैं। तो वन इंटरप्रिटेशन ऑफ दिस इज कि ये कास्ट बेस्ड डिस्क्रिमिनेशन है, बट आल्सो अगर हम देखेंगे कि जो जनरल सीटों पर क्यों ये नॉन फाउंड सुटेबल डिक्लेयर कर रहे हैं, अगर केवल कास्ट डिस्क्रिमिनेशन, इसका ये मतलब नहीं मैं कह रहा हूँ कास्ट डिस्क्रिमिनेशन रोल नहीं प्ले कर रहा है, कास्ट डिस्क्रिमिनेशन बहुत मेजर रोल प्ले कर रहा है, बट उसमें भी अब चूंकि गवर्नर्स अगर वाइस चांसलर उधर से अपॉइंट हो रहे हैं गवर्नर को पैसा दे के, तो गवर्नर को भी तो पैसा कहीं से निकालना है ना, और वो पैसा शायद जो है ये जो फैकल्टी अपॉइंटमेंट यूनिवर्सिटीज में हो रहा है अब वहां से निकालने की कोशिश की जा रही है, और जिसकी वजह से आप देखेंगे कि जनरल सीटों पर भी बहुत बड़ी संख्या में अब नॉन फाउंड सुटेबल डिक्लेयर करना शुरू कर दिए हैं। वो केवल मेरिट की कैपेबिलिटी कैपेसिटी नहीं है, बट आल्सो जो उनको चाहिए बैकडोर से, वो बैकडोर से मिल नहीं रहा, और इसका एक पूरा अपना मैकेनिज्म है कि कैसे जो है कैसे किसको ट्रांसफर करना है, क्या करना है, कहाँ देना है, दैट्स एन ए डिफरेंट इशू। सो यहाँ देखिए जो इसमें मतलब स्टेट एज ए एजुकेशन इंस्टीट्यूशन हम उसको उस पर्सपेक्टिव से देख सकते हैं। बस इस पूरी मेरा जो एक आर्गुमेंट ये है कि ये पूरी क्राइसिस इसको लाने में सुप्रीम कोर्ट का ही योगदान है। और मेरे जैसा आदमी अगर एक बार भी देखेगा कि कोई पावर मुझे लिखना होगा कि ये पावर गवर्नर को हैंड ओवर कर दी जाए, तो मैं 10 बार सोचूंगा, तुरंत मेरे दिमाग में आएगा कि व्हाट वुड बी इट्स इम्प्लीकेशन, कि गवर्नर को तो पुलिस ही नहीं अरेस्ट कर सकती। सो हम जो है उसको एवरीडे यूनिवर्सिटी मैनेजमेंट क्यों दे दें। बिहार में देखिए कि पिछले 1 महीने में गवर्नर ने एक दिन ऑर्डर निकाल दिया कि जो है उनकी, और गवर्नर का प्रॉपर सेक्रेटरी निकाल निकाल रहा है, ये भी नहीं हायर एजुकेशन सेक्रेटरी निकाले, कि जो भी लोग पीएचडी होल्डर हैं स्कूल और कॉलेजेज में, उनको अब जो है असिस्टेंट प्रोफेसर बना दिया जाएगा डेपुटेशन बेसिस पर। और ऐसे ऐसे उलूल जुलूल जो है ऑर्डर, फिर जब शोर शराबा हुआ तो 10 दिन बाद वो ऑर्डर वापस कर लिए। फिर अभी कल देख रहा हूँ कि यूजीसी का रूल ये कहता है कि जो है आपको मीन्स एवरी यूनिवर्सिटी इज मेड थ्रू ए एक्ट ऑफ द लेजिस्लेचर। सो हर यूनिवर्सिटी का जब कोई अपॉइंटमेंट होगा तो उसका एक सेपरेट एडवर्टीजमेंट आना चाहिए। वो गवर्नर ने एक एडवर्टीजमेंट निकाला है 5 यूनिवर्सिटी का नाम देके कि इन 5 यूनिवर्सिटी में हमको वाइस चांसलर चाहिए। तो जो है, तो बेसिकली जो सेरिमोनियल हेड था, उसको सेरिमोनियल हेड को सुप्रीम कोर्ट ने कन्वर्ट कर दिया। और कन्वर्ट किस फॉर्म में कर दिया? सेरिमोनियल हेड हैज बीन कन्वर्टेड एन रियल एग्जीक्यूटिव हेड। दैट्स अ बिग प्रॉब्लम। इवन रियल एग्जीक्यूटिव हेड को कन्वर्ट करने में भी प्रॉब्लम नहीं होती, बट सेकेंड मोस्ट इंपॉर्टेंट प्रॉब्लम इज इम्यूनिटी विच दैट हेड इंजॉय, कॉन्स्टिट्यूशनल इम्यूनिटी द हेड ऑफ द स्टेट इंजॉय। दैट इज बिग प्रॉब्लम, लाइक फॉर एनी सिक्योरिटी एजेंसीज। अगर आज की डेट में गवर्नर ऑफिस में 2 करोड़ 4 करोड़ रुपए की घूस दे के रखा हुआ हो, सीबीआई या किसी एजेंसी को क्लियर कट इंस्ट्रक्शन हो कि पता हो कि हाँ ये पैसा रखा हुआ है, they cannot enter in the premise, they cannot seize the money, they cannot take any legal action against the governor, even police। so ये सारा चीज जो है प्रॉब्लम, ये सुप्रीम कोर्ट की वजह से आई है। और क्राइसिस ऑफ व्हाट इज कॉल्ड, एक टर्म होता है गवर्नेबिलिटी क्राइसिस, क्राइसिस ऑफ द गवर्नेंस मीन्स सेंट्रलाइजेशन का नॉन फोरसाइटनेस आप ओपिनियन आप देखिए। एक और भी केस मैं इसी कॉन्टेक्स्ट में जिक्र कर देना चाहता हूँ, अपॉइंटमेंट ऑफ डीजीपी ऑफ ऑफ स्टेट गवर्नमेंट। सुप्रीम कोर्ट ने कहा कि सोचिए कि थाने का थाने का कप्तान से लेकर और जो है एडीजी लॉ एंड ऑर्डर तक, ये सारा अपॉइंटमेंट स्टेट गवर्नमेंट करेगी। लेकिन एक अपॉइंटमेंट के लिए ये इन्होंने ऑर्डर पास कर दिया कि उसको तो आपको पहले पैनल भेजना पड़ेगा 3 लोगों का, और वहां से जो है यूनियन पब्लिक सर्विस कमीशन, कौन है यूनियन पब्लिक सर्विस कमीशन? 3 ऑफिसर्स अपॉइंटेड, हु हैज बीन अपॉइंटेड बाय सेंट्रल गवर्नमेंट, उसमें स्टेट गवर्नमेंट का कोई रोल नहीं है। सो ऑर्डर ये पास कर दिए हैं कि जो है आपको डीजीपी के अपॉइंटमेंट के लिए 3 पैनल नाम भेजना पड़ेगा स्टेट गवर्नमेंट, यूनियन पब्लिक सर्विस कमीशन को। अब इसका इम्प्लीकेशन देख लीजिए क्या हो गया है। उत्तर प्रदेश जैसा राज्य पिछले 6 सालों से एक्टिंग डीजीपी के भरोसे चल रहा है। तमाम जो है पंजाब और जो है ढेर सारे जो अपोजिशन रूल्ड स्टेट हैं, इवन जो रूलिंग पार्टी द्वारा रूल्ड स्टेट है, उसमें भी ये प्रॉब्लम आ रही है कि सोचिए पुलिस जैसा प्रशासन जो है, जो कि लॉ एंड ऑर्डर जिसको हैंडल करना है, वो सुप्रीम कोर्ट की इस रूल जजमेंट की वजह से विदाउट जो है परमानेंट हेड ऑफ द स्टेट ही चल रहे हैं। आप आज की डेट में अगर स्टेट्स को चेक कर लीजिए तो आपको पता चलेगा कि जो है तमाम राज्यों में तो डीजीपी ही नहीं है, डीजीपी रिटायर हो गए, पैनल का नाम जो है गवर्नमेंट भेज रही है, और वो जाएगा नाम यूनियन पब्लिक सर्विस कमीशन, जब वो क्लियर करेगा तब होगा। सो जब तक क्लियर करेगा तब तक जो है उस आदमी का रिटायरमेंट आ जाएगा। सो दीज आर दी जो एवरीडे फॉर्म ऑफ द गवर्नेंस में कोर्ट की जो है प्रॉब्लम हो रही है। सेकंड क्वेश्चन जो था जूरी सिस्टम, देखिए जूरी सिस्टम का एग्जाम्पल मैंने इस वजह से दिया कि ये मैं समझ रहा हूँ कि हमारे समाज में जो है जिस तरह का कास्ट कॉन्शियसनेस है, उसमें लोग अपने कास्ट के पर्सन को, बेसिकली पीपल्स ओपिनियन आर मेड बाय देयर कास्ट एंड रिलीजन। सो जो उनकी कास्ट का व्यक्ति होता है उसको कहेंगे कि हाँ ये अच्छा है, वो चाहे गलत भी किए रहेगा वो कहेंगे हाँ अच्छा है। परिवारों में जो है कोई मर्डर करके, रेप करके, कुछ भी करके आ जाए, मोस्ट ऑफ द फैमिली जो है उसको डिफेंड करती हैं, लाइफ लॉन्ग उसका केस लड़ती हैं। ये हमारे अ, देश का सिस्टम है। लेकिन तो क्या जो जजेज हैं, वो जजेज जो है, जो ये पूरे सोसाइटल कंसिडरेशंस हैं, उस सोसाइटल कंसिडरेशन से वो अब्स्ट्रैक्ट हो चुके हैं, वो इन चीज़ों से बाहर हैं। इन सारे कंसर्न से ये इश्यूज हमको देखना होगा। क्या वो मीडिया के द्वारा इम्पैक्ट नहीं होते हैं या कम होते हैं, ज़्यादा होते हैं? दीज आर वन कंसर्न। बट जूरी सिस्टम जिस जिस वजह से इम्पोर्टेंस है, वो वो ये है कि वो ये बताता है कि जो जो जस्टिस है वो केवल कुछ स्पेशलाइज्ड लोगों का काम नहीं है। वो जस्टिस डिलीवर करना, वो वो दिस इज पार्ट एंड पार्सल ऑफ इवन ए कॉमन पीपुल, कि क्या उनके नज़र में न्याय है। न्याय जो है जिसे कहा जाता है कि कॉमन सेंस का भी एक न्याय होता है, कि लोगों को पता चलता है कि हाँ ये कॉमन सेंस application application of common sense of for delivering judgment is important। और बहुत बार ऐसा होता है कि मतलब जजेज नहीं डिफेंड कर पाते हैं। जब मैं कैम्ब्रिज यूनिवर्सिटी में था, सीजीआई चंचूड़ से एक महिला ने क्वेश्चन पूछा कि एक कोई ना 6 ईयर की बच्ची का रेपिस्ट था, उसको जो है इन्होंने, किसी जज ने ये कहते हुए एक्यूट कर दिया, कहा कि जो है एवरी समथिंग सेनर पर्सन हैज ए सेंट्रली फ्यूचर लाइक दैट, ऐसे ही कुछ फ्रेज करके यूज करके कहा। और जब उस महिला ने उसको पूछा, उस जज को, सो उस इश्यू को लेकर वो शर्मिंदा हो गए। ही वाज नॉट एबल टू आंसर दैट दैट क्वेश्चन प्रॉपरली। रीजन ये है कि आप जो है, भले आप बहुत, हम बहुत किसी चीज को लेकर नॉलेजेबल पर्सन हो, बट कुछ चीजें सोसाइटी भी बहुत बेहतरीन ढंग से जज करती है कि जजमेंट डिलीवर करने करने में। एंड इसके अलावा जो 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 ये जो जो जूरी सिस्टम खत्म होने का एग्जाम्पल है, वो एग्जाम्पल ये भी बताता है कि कैसे जो है एक पूरी प्रोसेस है इंस्टीट्यूशन को इलिटिसाइज करने की। उसके जस्टिफिकेशन कुछ और हो सकते हैं, कुछ भी हो सकते हैं। तो एक जस्टिफिकेशन उस समय था कि जी मीडिया इम्पैक्ट कर देती है। तो चलिए उस समय आपने मीडिया इम्पैक्ट करते समय कर दिया, तो उससे जो है, जो लोअर जुडिशरी है दैट गॉट इंसुलेटेड कंप्लीटली फ्रॉम पार्टिसिपेशन, गॉट ब्लॉक्ड ऑफ द ऑर्डिनरी पीपल। देन हायर जुडिशरी में आपने कह दिया कि नहीं जी हम ही अपॉइंट करेंगे खुद को, सो कंप्लीटली पार्टिसिपेशन गॉट ब्लॉक्ड। थर्ड, you went on saying that कि even we will not apply equality of opportunity principle। यहाँ तो हमारा हमारा pick and choose चलेगा कि whom we will be picking and choosing। So these processes shows an attempt to have control over the institution by certain people। And when these things starts happening, so institution का जब people do not see that they are part of that institution, or even they cannot be part of that institution in future, they start like opposing that institution। और ये कोर्ट के लिए, इंडियन कोर्ट्स के लिए बहुत बड़ी प्रॉब्लम है ये। पहले जो है एक सर्वे को भी ये रोके थे कि जिसमें जो है पता चला कि जुडिशरी का को लेकर सपोर्ट बहुत कम है इंडियन सोसाइटी में, और वो नाउ इट हैज स्टार्टेड रिफ्लेक्टिंग. सो दैट्स अ बिग इशू नाउ. Appointment of the judges, uh, yes, अपॉइंटमेंट ऑफ द जजेस देखिए, होना तो कमीशन के थ्रू ही चाहिए. मीन्स नीदर लाइक एग्जीक्यूटिव can make the appointment properly. Executive appointing the judges has its own consequences, very serious consequences. जजेज का मेजर रोल जुडिशरी का होना चाहिए अपॉइंटमेंट में, बट दैट डज नॉट मीन दैट यू कैन हैव you other people, like people from other field, should not have any say in the judicial appointment. Reason is that because judiciary impacts everyone, like every section of the society and every field of the society. So when something is impacting on me, why can't I have say uh, in 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 the appointment? So like commission system is of course one of the, like one of the best, or even has been found best solution till now. Only question is how you are going to like formulate commission and another thing. In addition to this, another what suggestion which I have been making since beginning, that people should have like right to at least place their case before the concerned authority, that I qualify to become judge of the court. And that can be only through the like issuing the proper application process. Yes.
Sir, we have another question lined up in the chat box for you, if I may read that. Arvind sir, you have to unmute yourself. You're on mute.
Can you read it?
Yeah, sure. The 2018 SC/ST Act protest reflected tensions between judicial decisions and public sentiment. Should courts consider the possible social and political consequences of their judgments, or should they decide cases solely on constitutional principles?
No. So yes, they must be concerned about because they are not delivering constitutional principles are for the people, for the welfare of the people, for the well-being of the people. And courts has to, when taking up the cases, they have to be concerned. They need to, or I would say, they should not take casual approach in dealing these cases, because it will have serious consequences. For example, uh, not only that scheduled caste SCST atrocity judgment, but judgment which was delivered in Tripura to include Methi community in scheduled tribal. Now you have seen that what has happened. A judge, in that case, a judge who was like not ready to go there to Tripura. He belongs to Madras, and he has written to Collegium when he was transferred. He has written that send me in any other court. I do not know like history, geography, and language, society, culture of Tripura. And Collegium said, no, you have to go there. And one judgment which he delivered, now you can see the implication of, of that judgment. So few issues are like settled in very different way. Sometimes a issue might look like it is not constitutional, but you cannot say anything. So like agreement between Methi and Kuki community, though you might think that it is not, it is a, it might look unconstitutional based on certain principle. But if you look another principle of constitution, take for example historical agreement, which is called pre-constitutional agreement there is quite a lot of writing on pre-constitutional agreement, historical agreements between community. That is how they are living peacefully. So using abstract principle in like conflict driven societies will have like serious consequences, and we have seen that in Manipur, though anger was targeted towards the ruling party, but honestly speaking, that judgment was initiated by a high court judge, and that high court judge was placed because of the like because of the careless like casual attitude of Indian Supreme Court Collegium, and it has resulted into that that in that way. So I would say that yes, when mass people are involved, when life of the people are involved in any case, then it is necessary that there should be proper analysis of the consequences of those. So yeah, that's all.
Thank you, sir. Shashank, sir, you may please answer the questions.
Yes, so the question is related to representation of all other people in judiciary as well as in litigation. So Sales raised this concern that how to improve representation of other communities and other groups in judiciary. I just want to say there are two, three things happened in the past. The first is that advent of national law schools. So national law school gave a kind of entry to all other people, those who are from marginalized section, and there are some initiative which are being propelled by some scholars like Shamnath Bashir, and he has started idea. So this is a one way of increase diversity in legal field, and thereafter in litigation, and thereafter in other parts of legal profession. But when you see bar as well as advocates who are representing state and other important offices, you'll not see that kind of representation what what is required by the institution. So in that view of the matter, I have one concern that in this institution as well as state bar council, there's no data, and they are very hesitant to collect data about lawyers, about their caste, about their disability, about their gender. So this is very, and they are very, they feel that they are very sacrosanct, and they don't want to divide bar on the basis of caste. But the background of this act is that they don't want to give representation. What happened that I filed the public interest litigation in relation to representation of person with disability, lawyers who are person with disability. But and on the basis of the fact that there should be representation of person with disability in the bar as a member executive or as a other secretary, because of the reason that there is no one who can raise their concern. And in other jurisdictions, I saw that lot of disabled lawyer associations are in existence, like there in US, there is deaf lawyer association, there is a blind lawyer association, but India there is no association. And I suggested in that public interest litigation ki, look, in your enrollment form there should be one column where a person, where is a lawyer who's a person with disability, he can point out his disability, so that you have data, and whenever they want to claim their right, they can claim legitimately and they can claim vehemently, because now the data is there. In the same manner, and but the court was not inclined to uh, pass this order. The reason is very simple, because in article 15 there is a rule, there is a law that state can make act or for betterment of children and women, but it was not in relation to person with disability. So that is a very big problem. And in a same manner, the data in relation to marginalized class, EWS, PWD, and OBCs lawyer or women, or tribal lawyer or women, or transgender lawyer or women, are not there, and the bar is not in favor of catering or gathering those kind of data for the benefit of those lawyer who are at the end of margin. So that is the problem. So the first and foremost thing is that one should, I mean, the group of people, they should start advocating about or compelling them to collect data, and so that they can create a kind of pressure on judiciary and other bar association, because representation is very important. If you were not able to say that these are the lawyer, and these has a these lawyer has a different kind of problem, but it is not being redressed. So in that view of the matter, it's very difficult to have a effective representation. That is one thing. Second thing is that to ensure representation of all these lawyers, um, they should question their lawmakers, that like in Uttar Pradesh, people should law some kind of association should be there. They should write these kind of thing to chief justice or political ministers, that you should do something in relation to this, so that the representation can be ensured. That is the one way. So, and yes, you are right that all these judges, I mean, you are talking about the Patna High Court as well as other high court. So it's very true. Except lower judiciary, where is the constitutionally mandate that you will have to give reservation to these kind of people. That's why you are able to see the number of people, even the disabled lawyer are there. But the same kind of thing is not there. Even if a disabled lawyer, it's very difficult to find a person who's a disabled and who's a lawyer and he can get a chance in high court, because they don't want that kind of people to come to the high court. But I feel that for these advocate or standing counsel, for them there should be some mechanism like some exam or something like that, because people should should start questioning about all these kind of appointment. Otherwise nothing is going to be changed. So the what is happening right now in Supreme Court, the person who is from Bihar, he is being appointed as a standing counsel for the state of West Bengal. He has no idea. The person who is from Delhi, he is being appointed as a standing counsel for the state of Tamil Nadu, who has no idea of the language of that particular state. So it's very difficult to function also. So the all these kind of appointment is not only taking the rights of particular person of that particular state, but it is also mismanaging the whole litigation thing. That's it.
Thank you for the answer, sir. We have another question lined up for you in the chat box. If I may please read that.
Mm.
Uh, as you raised concern about the law representation of the backward classes in the judiciary.
Sorry,
Yes,
where is
sir.
that?
Sorry, sir.
Who has asked this question?
Advocate Devinder has put this question at 6:46 p.m. over the chat box.
The presentation on backward class and judiciary, my question is what mechanism or method can effectively increase their representation? Would the National Judicial Complaints have been a suitable mechanism to address? Now, the point is that, I mean, all these kind of change takes a lot of time, because what happened that you are saying something now, what is happening that the people think that higher judiciary is very sacrosanct, and if we'll start talking about the caste, we are segregating this judiciary, and we are recruiting less meritorious people. So for that particular person, it needs lot of pressure and lot of advocacy. It will take time. Now the problem is that no lawyer, I mean, there's no association, there's no voice that who can say that, "Ki, look, you will have to appoint these kind of people so that they can also represent their class of people." Lot of litigations in Supreme Courts are from that particular class. But it's very ironical that the state who has a tribal, like a Jharkhand is a tribal state, and you will I mean, you will amazed to find that there is no one who's a tribal and who has become a lawyer from, I mean, the Jharkhand constituted in 2000, and now it's 2026. They failed to recruit a single lawyer who's a scheduled tribe in Supreme Court. So it's very painful. But the point is that you people should come together. They should raise their voice, and to raise their voice, there are a lot of way. Like you will have to write, you will have to be vocal in different means. So that is the one way. Now the National Judicial Appointment Commission, if it comes, and I mean, if they have this concern, they have this priority, then they will definitely do something. But I don't think that the people over there, they feel this thing. So it should start from the, from very from district court and high court, and people should start questioning about the appointment, and they should question about their appointment from that particular group. Yes.
मैम अनम्यूट कर लीजिए मैम. Still it's muted.
You are not audible, Anushika, you are not audible.
Am I audible now, sir?
Now you are audible.
I extend my heartfelt gratitude to all the distinguished speakers, Dr. Arvind sir, Shashank sir, and Dr. Amit sir, for generously sharing their knowledge and enriching this dialogue with their expertise. I also sincerely thank all the participants who has joined us today and contributed through their attentive presence and thoughtful questions. The quality of any constitutional dialogue depends not only on its speakers but also on engaged audience willing to listen, reflect, and participate. We hope today's discussion has encouraged all of us to think more deeply about the delicate balance between democratic dissent, freedom of speech and expression, and the independence of constitutional institutions. Thank you once again for being a part of this inaugural lecture of the Nalanda. Before we conclude, I invite all of you to stay connected with the Nalanda. You may subscribe to our newsletter through our website to receive updates about our upcoming lectures, discussions, and any other events. Once again, thank you all for your time and participation. Have a wonderful evening. Thank you. Thank you, sir.
Thank you, Anushika. I think Raja wants to say something.
Raja, sir, you want
He raised his hand.
I think that was by mistake.
Okay.
Thank you, sir.